The next three rules are about qualifying children. And qualifying child is the same rules as what we learned for dependents. So that's going to be JARRS, which is joint return, age, relationship, residency, and support. However, for the earned income credit, the support test does not count. So if you actually have a child who is somehow self-supporting, maybe they have a trust fund, maybe they have an inheritance, maybe your spouse died, and now you're trying to raise them on your own, but the life insurance, maybe part of the life insurance might have been in their name, that would count as a child providing their own support. Also, the Social Security survivor benefits would be in the child's name. That would also count as them providing their own support. So they might actually be self-supporting. So they wouldn't count as your dependent for tax purposes, but they would still count as your qualifying child for EIC purposes. That's a pretty rare situation, but just remember that the support test is excluded for purposes of earned income credit. Okay. So we're going to review what these four tests are. The relationship test is the child is your son or daughter, or your descendant, or your brother or sister, or their descendants. And that includes stepbrothers, stepsisters, half-brothers, and half-sisters, and their descendants. This also includes foster children, and any time there's an adoption, that changes the legal status to be exactly the same as if it were a natural or blood relationship. Okay, so Julie has a nephew, Al, and Al is 14 and lives with Julie. That nephew relationship is one that meets the relationship test. And remember, when someone writes niece or nephew or says that someone is their niece or nephew, double check that they're actually talking about their brother's child or their sister's child. Also, remember when we talked about Form 8332, which was an exception to the residency test, that means if you're the custodial parent and you sign Form 8332, then the non-custodial parent gets to claim that child as a dependent. They also get the child tax credit or other dependent credit, whichever one that child qualifies for. However, for purposes of the earned income credit, that 8332 is meaningless. The custodial parent always gets the earned income credit. So if a child lives with you for 8 months and with the other parent for 4 months, you're going to get the earned income credit, even if you sign the form that allows the other parent to claim the child as a dependent. Okay, so adopted child is the same as a natural child, and a foster child only counts if that child was placed with you by a competent authority, meaning a state or local government agency, a tribal authority, or a competent organization licensed by the state, like an adoption placement agency or foster placement agency. Also, if they were placed with you by a court, family court, that would also count as being placed with you as a foster child. Okay, the next rule, the age test. Your child must be under 19 and younger than you, or a full-time student under 24 and younger than you, or any age if permanently and totally disabled. So in this example, Todd is 19 and lived with his parents, but if he was not a student, he is too old to meet the age test for earned income credit. If he was a student, he would qualify. in this example, Thelma is 25 and she cannot work because of a severe physical disability that counts as permanently and totally disabled. So she would be a qualifying child for the earned income credit. So I actually had someone in her 70s who was taking care of her 68-year-old brother who had a permanent total disability, and they were living together. That's her qualifying child number for earned income credit. Mm-hmm. And even if they were older, even if the brother was older than her, the permanently and totally disabled part does not say younger than you. So you can even count your older siblings as your qualifying children. IRS is probably going to question that, but as long as we have the documentation to prove that's what's going on, they'll have to accept it. Okay, the third test is the residency test that says your child must have lived with you in the United States for more than half of the year. So this is slightly different than the rules for a dependent, because a dependent can live with you anywhere in the world and be your dependent. But to qualify for earned income credit, they have to live with you in the United States for more than half the year. And we have the same rule for temporary absences, which means if you are temporarily away from home, or if your child is temporarily away from home, or both, because of illness, school, business, vacation, military service, or detention in a juvenile facility, then they're still considered living at home, or you're still considered living at home. That would not include, however, an adult jail or prison. So if you go to jail, you're not temporarily away. But if your child goes to juvie, they are temporarily away. But if your child goes to grown-up jail, then that's not a temporary absence. If a child is born or died during the year, then again, to look at the half the year rule, we only count that part of the year that the child lived through. So again, if a child was born today, October 7th, then there are 30 plus 31, 61. There are 84 days left in the year. So out of those 84 days, if the child lived with you at least 43 of them, more than half, then they would be considered living with you more than half the year. Okay. For purposes of living in the United States, we only count the 50 states and District of Columbia. So if your child lived with you in Puerto Rico or U.S. Virgin Islands, that does not count for earned income credit. The IRS can often ask for proof that your child lived with you, especially if you're claiming a child who's not your son or daughter. So you may want to start gathering those documents even before you file your taxes. But if you're talking about claiming your niece or nephew, those documents would include any school records, hospital records, doctor visits. You can get a note from your employer if they happen to know your home living situation, your landlord, your attorney, a social worker, anybody that is not related to you that knows your living situation. And the more official, or like if they're a government worker or your employer, the more official they are, the better evidence that is. And you would want to have something covering at least 7 of the 12 months. So if your child is too young to be in school, you could ask your daycare provider to write a note saying that you pick up and drop off your kid every day for these 4 months, and then you'd have those 4 months covered. You find something else for 3 more months out of the year. Maybe they started school in the fall, and you get those school records. Any good document should show your child's address, and it should match your address. So you could even get, if you get mail in your child's name, keep that mail. So like a social security card might be mailed to your child. Keep that, like maybe make a scan of that envelope before you open it. That would help prove the child lived with you at least that particular day. Most of the time, the IRS isn't going to ask, but when they do ask, it can be hard to come up with those records after the fact. So it's always helpful to have those records ahead of time when it's so easy to find. Okay. And finally, the joint return test is the same as the joint return test for dependency. That just says your child is either unmarried, or if they are married, they're not filing a joint return, or if they file a joint return, it's only to get their withholding back. Okay, our 9th rule is that only one person can claim any child as a qualifying child. And that's for all tax benefits except in the case of an 8332. So if you claim a child as a dependent, you get child tax credit or additional child tax credit or credit for the dependents. You get head of household filing status, you get child and dependent care credit, you get to exclude dependent care benefits from your job, and you get the earned income credit. All of these tax benefits go together, so you can't split them up. You can't say, I'll take this, and grandma, you can take this other benefit. It's all together. The only time these are ever split up is in the case of Form 8332, in which case the child tax credit goes to the non-custodial spouse and everything else remains, non-custodial parent, not necessarily spouse, and everything else stays with the custodial parent. This slide is slightly wrong. You don't always have a choice who can claim the child, as we'll see in the tiebreaker rules, which are the same as the tiebreaker rules for dependents and everything else. So again, the tiebreaker rules, if one person is a child's parent, the child is that parent's qualifying child, unless the parent wants to opt out, which is part of the last rule. If both parents could qualify to claim the child, and they're not filing a joint return, they can actually choose between them which parent will claim the child. But if they don't agree, or they both claim the child, then the child will go to the parent with whom the child lived with for a greater part of the year. And if that's still the same, it could be the entire year for both parents, then it's going to go to the parent with the higher adjusted gross income. If none of the people involved in the tie are the child's parent, or if the parent could claim the child and chooses not to, then only the person with the highest adjusted gross income out of all the people who could potentially claim that child can claim that child. So we have occasionally very complex households. We'll maybe have somebody living with their 3 adult children and their 3 adult children's spouses, and then the 14 grandchildren all live in the same house. Then to untangle that, we look at who is each child's parent. You have the first choice, but then after the parent, only person in that entire home that could claim the children is whoever has the highest adjusted gross income. So here's our example. Wanda is age 24, and she lives with her mom and her child. So there's two possibilities. Wanda makes less than her mom, then in that case, Wanda has first choice. If she doesn't want to claim the child and let her mother claim the child instead, she has that option. But it's always Wanda's choice as a parent. If it were the other way around, though, and Wanda made more than her mother, then Wanda is the only person that could claim that child. Again, I said, in the case of a Form 8332, that's the only time that those tax benefits don't all go to the same person. Rule number 10. So this is the last rule for if you have qualifying children, is that you cannot be the qualifying child of another person. So qualifying child for earned income credit purposes is technically slightly different than being a qualifying child for dependent purposes. So remember, you can claim qualifying child for earned income credit without the support test. But if someone could claim you as a qualifying child for earned income credit purposes, then you cannot claim any qualifying children of your own. So we always have to, if someone is under 24, we always have to double check that they're not eligible to be claimed as someone else's child. And then down here, if you're the qualifying child of another person, you cannot claim the earned income credit even if they don't actually claim it. So a lot of these questions about dependency and qualifying children ask, could someone claim you, or do you qualify to be claimed as a dependent, or do you qualify to be claimed as a qualifying child? It doesn't matter what they actually do. So if you're living with your parents and you're under 19 and you want to claim yourself on your tax return, you can't do that. You're their dependent. Even if they say, well, we don't plan to claim you this year. If you meet all the tests to be the qualifying child, you can't. So we're just finishing up the rules on claiming earned income credit with qualifying children. So earned income credit is, again, seems fairly complicated, but most of these rules are either self-explanatory or retreads of rules we've already learned. So I'll go ahead and summarize the first 10 again. So in order to claim earned income credit, your earned income must be, or your adjusted gross income must be below a certain threshold. Second, you and your spouse must have Social Security numbers, and all of your qualifying children must also have Social Security numbers, which are issued by the due date of the return. If you're married, you and your spouse must not live together at any time during the last 6 months of the year, or married filing jointly, if you're not filing a joint return with your spouse. You must be a U.S. citizen or resident alien the whole year. You cannot exclude foreign income, earned income. Your investment income must be below $11,000. You must have earned income. And if you have a qualifying child, they must meet the joint return, age, relationship, and residency tests. Those are the same tests we used for determining if they're your dependent in the first place. And number 9 was you cannot split up this benefit. So if you claim your child for earned income credit purposes, you must also claim them for all the other purposes, except for the case of divorced or separated parents, where the non-custodial parent is claiming the child as dependent. The non-custodial parent gets the child tax credit, additional child tax credit, or credit for other dependents, but that's it. The custodial parent still gets earned income credit, head of household fund incentives, child and dependent care benefits, and the earned income credit. And the last one is you cannot be the qualifying child of another person. So if someone could claim you as a qualifying child, you cannot claim the earned income credit. That's can they claim you, not do they claim you.
Right.
You're not considered a qualifying child of another taxpayer if they are not required to file a tax return and they don't file a tax, either don't file a tax return, or if they do file a tax return, it's only to get their withholding back.
Right.
So this is where we got the example of a single mother who was on Social Security and that was her only income. So then her 17-year-old son could claim the earned income credit based on his younger siblings. Because the mother is not a taxpayer for the purposes of this rule.